envisaged this bill as being a private bill, and so we had proposed in one of the clauses an amendment that provide some distance as a form of protection between the adult and children. Even if it wasn't cannabis, it was simply smoking tobacco. One would expect that there would be a reasonable distance between the child and an adult, so as to protect them from the inhalation, what we would call a secondary smoking. Chair, on the question about the schedules, I will invite, if you are in agreement, Ms. Fafudi, who is from the South African Health Products Regulatory Authority, to explain the scheduling. But the intention in the bill, and which we support, is to try to separate the private use from the medicinal use, because there may be a variety of approaches around the medicinal use, which may be different, and SAPRA should be allowed to do its work around the medicinal use differently, and so this should not be affected by that. Chair, on the question about the information relating to adolescence, the psychosocial and the cognitive impacts, etc., much of that has been referenced from the Medical Research Council, and I will endeavor to engage the MRC and supply the committee via our parliamentary liaison officer, Mr. Khatla, the information relating to that research, which hopefully will assist you in your deliberations. So, Chair, if you allow, I will ask Ms. Fafudi to just explain the way the schedules will be managed, if that's okay. Thank you.
Thank you very much, Ms. Fafudi.
Thank you very much, Chair, and Dr. Pillay. Chair, if I may start, I would like to start with the, there was a comment where about access to private use for medical treatment. So SAPRA has got a controlled compassionate use program where a product needed for treatment will be made available on a patient named basis. This is through Section 21 authorization. So there is no need to panic there. There is that provision that we make. And in terms of the amendments that were made, Chair, I just want to summarize that following the Concord judgment and also following the interest that was growing in terms of cannabis, and through the engagement with various stakeholders, Chair, we noticed that, okay, cannabis is a new emerging industry that people see it as with a great potential. And therefore, SAPRA, through the Medicines Act, which is our mandate, we needed to look at how is cannabis controlled locally and internationally. And as a signatory to the UN, we, in terms of the 3 UN Convention on Narcotic Substances, the 1961 Convention, the 1971 Convention, both on narcotics and psychotropic substances, and the 1988 Convention, which prohibits illicit trade in narcotics and psychotropic substances, we are obliged as a country to ensure that cannabis, which falls under narcotic substances and psychotropic substances, we align in terms of the regulation thereof. So when making the amendments to the schedules from SAPRA's side, what happened is that we removed the entry or the inscription of cannabis, which was under Schedule 7, which were prohibited substances. And then we therefore regulated tetrahydrocannabinol and THC and CBD. So in this regard, SAPRA has got 3 framework, which is the complementary medicine framework, the orthodox or allopathic medicines framework, and also the medical devices framework. So we therefore also removed the low THC cannabis, which is also known as hemp, from the schedules, so that the Department of Agriculture can immediately make use of this low-hanging fruit in enabling industrialization of cannabis. And what also from the exclusions that Dr. Pillay has alluded to, in terms of complementary medicines, we therefore said if they meet the definition of a complementary medicines and the maximum daily dose as prescribed, for example, 20 milligram as maximum daily dose for CBD. The container should not exceed 600 milligram. With those minor claims and no medicinal claims at all, that product will be enabled. So, and this, because CBD is a Schedule 4. Schedule 4 substances can only be available through pharmacies or facilities that are enabled, and those products need to either be registered or authorized by SAPRA. So in this regard, therefore, this enables CBD containing products to be available through the market. And also those with less than the controlled maximum quantities can also be available either in the form of nutraceuticals, either in the form of pharmaceuticals or cosmetics or any other. And if they are not health related, they will not be regulated through SAPRA framework. They can be in the master plan, it is clearly outlined. The Department of Agriculture will demonstrate that, and we are working closer with them together with the DTIC and other stakeholders, the small business, to make sure that the cannabis master plan will develop a framework that will ensure that the low risk or non-medical cannabis will be enabled, the access will be enabled. But we need to remember that in terms of THCs, we are reporting to the International Narcotics Control Board, and before we can even avail a cannabis containing products, whether in the raw form as a plant material or in its finished product, we need to first get a quota from the International Narcotics Control Board, which is a body of the UN. So, and we need to submit a consumption data for South Africa that is expected. And on a quarterly basis, every 3 months, we need to report on that consumption from growing to production and also to final use in terms of the finished products. So that regulation, it is in terms of how we align ourselves internationally. And another purpose of the master plan was to ensure that whichever framework that South Africa and position that South Africa needs to take at the policy level, it needs to make sure that there is regulation that will be known and communicated with the UN in terms of the position that South Africa wants to take in terms of industrialization and commercialization of cannabis containing products. But the most important thing, we need to make sure that there is no diversion into the illicit market. There will always be control and oversight in this regard. Chair, I hope that answers the question. And from the Medicines Act side, we make the commercialization of medical cannabis available through licensing and issuing of permits, working together with the Department of Health in this regard. And there is that framework available. And we are also working through the master plan to just look at possible access to those those who are able to comply with the requirements of SAPRA, but the mandate of SAPRA is in terms of quality, safety, and efficacy of all health products that are available into the market. So that is the mandate of SAPRA, and hence with this new emerging industry, what SAPRA is doing is engaging to ensure that in enabling access, we retain the aspect of patient safety, product quality, and ensuring that those products that are in the market are effective for what they are meant to do. Thank you, Chair.
Thank you, Chair.
Thank you very much, Ms. Bafude. Dr. Pillay.
Thanks, Chair. No, that completes our responses. Thank you.
Thank you very much. Members, are there any further questions or comments? Honorable Swart.
No, thank you, Chair. I think I'm trying to understand from SAPRA's perspective, and I notice on the chats there's a lot of comments that we hopefully will engage with during the public hearings. You indicated the issue relating to the Section 21 program, and I'm trying to understand the application of that program. Would you please unpack that? And you, when you relate to THC, CBD, are all cannabis products, whether it's THC, CBD, considered medicinal and then requiring Section 21 compassionate usage programs? And then obviously the separation of the hemp is an important issue which we will deal with. But I noticed in your explanation, you distinguished between cosmetics and health related, and I'd like you to just clarify whether you consider both THC and CBD as health related matters in terms of the schedules, because I'm trying to understand, and we'll have to engage maybe further with the department as we get an understanding of the health implications. So I'd like you to unpack the Section 21 compassionate usage program as opposed to getting a CBD product in terms of Schedule 4 from pharmacies. I would presume that that does not require Section 21 application because of the nature of CBD as opposed to THC. I just need some clarity. Thank you, Chair.
Thank you very much. In the absence of no further questions, over to you, Dr. Pillay.
Thank you, Chair. I think this question is probably best responded to by SAPRA, since they are responsible for the schedule. So if I can ask Ms. Fafudi to just explain the regulatory process there. Thank you.
Thank you, Dr. Pillay and Chair. So with regards to the Section 21, at the moment in South Africa, there is no registered product that contains cannabis material, CBD or THC. So therefore, anyone who wants to use this for medical purpose, they are able to do so if they go through our Section 21 application route, and this will be facilitated by the health practitioner or physician who is treating that patient. And in terms of
Ms. Fafudi,
yes,
can you correct your camera? We can't see you properly.
Chair, I've got a problem of network. Do you, I switched it off because I'm thinking that I might have challenges of network where I am.
No, you can just show it once and then switch it off so that members of the public can see you.
Noted, Chair. Can you see me, Chair?
Yes.
Okay. So in terms of Section 21, which I explained as a compassionate care program, this one relates to medical or health products, as we currently do not have any registered product in the market, and access can be through it can be through Section 21 with the facilitation of a treating healthcare practitioner or physician. And the other one, in terms of what Mr. Swart has explained, it's a bit complex for me maybe to explain through this program, but due to the time limitations. SAPRA only regulates the health products. However, in terms of the schedules, remember there are active pharmaceutical products and also raw materials that we regulate. So the facilities, when I was explaining that we need to license the facilities that have to produce certain products, so in terms of Section 22C of our Act, I was also alluding to the fact that for products to be available in the market, they need to come through to us where they are related to health. However, in terms of cosmetics, we need to remember that in terms of the cannabis as a raw plant, it contains both THC and CBD, hence it is regulated through the SAPRA framework. However, if it is a law containing THC, in terms of the prescriptions that Dr. Pillay has alluded to, it will fall either under the regulation of the Department of Agriculture, provided that the CBD content as well is below the prescription. So it is a bit complex in that regard, but where the minimums are lower than SAPRA to regulate, SAPRA will not regulate. But in terms of scheduling, if they are higher, SAPRA will come in, because SAPRA will need, together with health, will need to report to the International Narcotics Control Board when it comes to consumption of these substances. So because cannabis on its entirety falls under narcotic substances, and we will need to request quotas at the moment in terms of the policy framework that we are aligned with internationally before we can even start consuming in this regard. So this is what I mean, Chair, when I say that even if it's a cosmetics, we need to first know what the raw material is, the source is. Will this fall under SAPRA mandate, or will this fall under the other mandate in terms of whether it's health, in terms of foodstuff, or cosmetics as well, or whether it will fall under industrialization, which is low THC and low CBD, which will go under the Department of Agriculture. But we are, through the Cannabis Master Plan, we are engaging with relevant stakeholders, including the public, to just explain this framework of local and international control. Thank you, Chair.
Thank you very much. Honorable Swart, is it a new hand or an old hand?
Chair, I understand we have limited time, so I just want to understand, and I'm grateful to Ms. Fafudi for explaining a very complex issue. This is not a terrain that we on the Justice Committee normally go into, but we need to understand it very carefully. And given the fact that she indicated that time is limited, but I'm also looking at some of the comments that are coming in and that are very helpful as well. I would ask her to maybe provide us with a written understanding of the process at her convenience. But I just need just one question. So do you understand it correctly that for any access of any medicinal THC or CBD product, one has to go through the Section 21 process, any practitioner? And what is the cost of that process? Do you perhaps know? And possibly you could, at some stage, you might not have the information now, but give us an indication of how many applications have been received and how many have been approved. And obviously you might not have that information now, but Chair, we do need to get more into this information. Thank you so much.
Thank you. Ms. Bafute.
Thank you, Honorable Swart. Yeah, in terms of what you are asking, sir, we will need to compile that response for you. But at the moment, to access medical cannabis or THC, CBD containing products, it will be through the Section 21 authorization. So there was an exclusion notice. If you look at the amendment to the schedules, there is provision for certain products to be available which are low CBD and low THC containing, which follow a framework that does not fall within the medicines, and those can be available. And those that are claiming to be complementary medicines. Also, in terms of the exclusion notice, you will note that we make provision for certain products. However, those products need to apply for a complementary framework. They have to apply for a license. They need to be evaluated by SAPA. They need to meet the definition of what a complementary health product is. So this, again, is just to make sure that the public is safe from products that are claiming to be treating or claiming to be alleviating certain conditions without those having been tested by SAPRA. Hence, we are saying that all the players that are making certain claims, if they're saying they're falling under the complementary rules, they need to be tested through that process. They must apply to SAPRA for a license, and the product must be also listed through that application and provide evidence as such. So in the meantime, the safest route is to go through the Section 21 authorization, as we do not have at the moment any registered product. And we will provide that information, Chair, to Honorable Swartz when, if we can be given an opportunity to compile that. Thank you.
Thank you. Please send it to the committee secretary. It will be distributed to all members of the committee. Dr. Pillay, if I may just ask one question. Were you not given the opportunity when the bill was drafted to raise your issues when the bill was drafted by the officials in the Department of Justice?
Chair, I'm not sure if it was circulated through the departments, but we certainly had not had sight to it as officials. So yeah, this is the first time we've seen it as such.
Okay. Who is representing the Department of Justice?
Mr. Chairperson, it's Ms. Pillay and Robert Sir from the Department of Justice. Regarding the bill, there was an interministerial committee under the Department of Health that were mandated to look into aspects regarding cannabis. And the bill was drafted in consultation with that committee. That committee, among others, included the Department of Health, South African Police Service, Department of Social Development, and various other departments. So the bill was therefore brought to the attention of the Department of Health. When the bill was finalized, I believe it was sent through to the various departments, including the Department of Health, to provide responses thereon. That was done in terms of a ministerial letter from the Department of the Minister of Justice, and all comments that were received were taken into account. I don't know if Dr. Pillay was part thereof, but I think Ms. Fufudi was also on that committee, if I remember correctly. Thank you.
Thank you very much. Because on our side, we take it that a bill that comes to Parliament represents the executive, and processes within the executive must ensure that the executive speaks as one. So I think it would be important that in the few days that you continue to confer so that you are not very far from one another.
Noted, Chair. Maybe my other colleagues were part of it, but I wasn't part of the process. Thank you.
But when I asked you, I was asking you as the Department of Health, not as.
Okay.
Yes.
Chair, maybe Advocate Marbello can confirm whether he was part of that process. I'm not sure.
No, I think for progress' sake, you have areas where I think you are not very far from one another. I think if you can further confer, and then when we start to process the bill clause by clause, by that time you should have conferred with one another again.
Okay, Chair, will do.
Thank you very much. Let's step off from this process. Thank you very much to the Department of Health for the good presentation. And I think you have made us to think deeply about the process. It's quite technical, especially at the definition stage. We really request that the information that was requested by members that it be given to us so that we can further consider it when we do clause by clause tweaking of the legislation after the public hearings. And it will still be relevant during the public hearings that we have that background information before we process the bill clause by clause. Thank you very much, Department of Health. Tomorrow we will get a presentation that will be led by the Department of Rural Development and Agriculture on the master plan that will take into consideration some of the issues that were raised today: the commercial side, the industrialization component, the health component, the education component, the innovation component led by science and technology. It's quite a comprehensive presentation, but we would also want to know, since the master plan was drawn up, what has been done to implement it. So that would be done tomorrow. And then thereafter, we will go to the public hearings on the 30th and the 31st, and then we will take it from there, depending also on how many comments we have received, how extensive are they, then that will guide us on the number of days we will take for public hearings. But for now, we have budgeted for 2 days for public hearings, which would be from the morning until evening, so that we try by all means to ensure that by the end of this term, we should have concluded this bill, and this bill serves before the National Assembly, so that we can allow the NCOP to undertake its own processes before it goes to the President for assent. Thank you very much.
Chair, Swart here.
Honorable Swart.
No, thank you, Chair. I just noted one or two of the comments that there was a deep concern about rural farmers not being able to make submissions or participate due to time shortages, but I'm sure you will consider that as well to ensure that everybody has the opportunity to make inputs.
Honorable Swart, this, if you remember, this bill was advertised twice, even last year, and when we gave an extension, and then we further invited members of the public again to make comments. So it has been in the pipeline since last year, where we invited members of the public, and then the committee asked that we extend it because we received complaints from the farmers in the Eastern Cape that there was not enough time to consult them. The space for public comment was further extended, but we will discuss that when we deal with the public comments.
No, thank you, Chair. I was referring to those that have made submissions as well, but thank you for your explanation. Thank you, Chair.
Thank you very much. Can you go to the next item? Dr. Pillay, I know you've got other issues, pressing issues to deal with, and your team. You are excused if you want to if you have other pressing issues. But if you don't and you want to be part of our committee, you are still welcome.
Thank you, Chair. Thank you very much. No, we certainly will want to accept. Thank you. Okay. Thank you. All right.
Thank you very much.
All right.
Criminal procedure. Can we have a 5 minutes break to allow the Center for Child Justice to fly to their slides? Can you come back at 10 to 11?
Karabo, Miss Karabo.
Morning, Sia, I'm here.
Can you test? Can you share and just put on your camera, and you can test your audio? Can you do that? Okay, your
But
blinds,
you can hear me, no?
Yeah,
Oh,
can
yeah,
you
the
close
blinds.
your blinds? Yeah, but we can
I'm
see
just
you.
gonna turn that.
Yeah, yes, that's perfect.
Yeah, it's fine. There's one that's broken, so
Okay,
it causes a problem for me.
can you share so that we deal with that?
Sorry.
There should be a green button. There you go. Yeah. Can you move up? We're going to start just to see if it's working. Okay. Yeah, that should be fine. Yes. Maybe increase the font. I don't know. Increase the size from 100 on the bottom of your screen. The bottom right. Yeah. It should be. Yeah. Can you? Then you scroll down.
Better.
That's much better.
Okay.
Okay. Thanks, ma'am.
Thank you.
The chair will come and say you can continue. We will continue at 10.
Okay, thanks.
Thanks, ma'am.
Which one?
Thank you. Good morning once again. Who is leading the presentation?
Morning, Chair. It's Karaba Oza here from the Center for Child Law.
Good morning, Ms. Ozahe.
Yes, Chair. May I proceed?
Yes, please.
Thank you so much, Chair and the members of the committee for this opportunity. As you would have noted, our submissions are not very extensive, which is a good sign that we are actually pleased about the amendments that are being made to the Criminal Procedure Act, particularly following the judgment that we had in the Constitutional Court about the publication of identifying information of people who are child victims, witnesses, and offenders, and also the protection continuing beyond when they turn the age of 18. So just by way of introduction, the Center for Child Law is at the University of Pretoria, and we do litigation, advocacy, and research, and we were part of the applicants in the Constitutional Court judgment that led to these amendments that are before Parliament today. So really, mainly we have comments in relation to two sections. The first one is really looking at section 1543 in relation to the lead in relation to the provision that no person shall publish in any manner the information that we know that the various sections deal with in relation to the identity of child victims, offenders, and witnesses. We have looked at the fact that, you know, when you just kind of Google the word publish, the old forms of publish kind of pop up in the sense of it's in a book, newspaper, and all those things. And we are of the view that in relation to our current space where social media publications are quicker than any other forms of publication, things are circulated on WhatsApps and all such forms of communication, we are of the view that maybe a need to, and I'll go to what we're proposing there may be a need to consider inserting the words that where you are saying that publish, you include that on any social media or electronic platform, so as to make it very clear that when we're talking about publishing in any manner whatsoever, we include these forms of platforms, just for clarity, and so that nobody can say they didn't know that. And we've seen it that on so many occasions, before you know it, things are already on WhatsApp and on all those platforms, and when you try and get people to retract them, the damage has already been done. Hence our proposal that we should strengthen just the wording in relation to what do we mean by publish, and make it very clear that publish also includes the sharing on social medias and other electronic platforms. And then, Chair, the second and last submission that we make relates to the extended protection. And maybe here I should just remind members that when the case was litigated, this very case that led to the amendments, there was a real life client, the person who was affected, whose name on the case it was known as KL, but everybody knows by now that the person was also what her real name is Michelle Solomons, but she was Zephanie Nez, the child who had been abducted. And when we litigated the case, it started with the media threatening to reveal her identity when she was 17. They said they will reveal her identity when she turns 18. And before mounting when we did the constitutional challenge, we had to do a part A and a part B. And the part A was to get a court order that immediately protected her identity, while the litigation in relation to amendments to section, challenging the section, took place all the way to the Constitutional Court. And when we were just finishing the Supreme Court of Appeal, going to the Constitutional Court, KL or Michelle or Zephanie Nez wanted to reveal her own identity. And because there was a High Court order that had said that nobody must reveal her identity, we had to go to the High Court and ask the High Court to lift that court order that had said that nobody may publish information that reveals her identity. And it's because she had written a book, she was about to publish the book, and wanted everybody to hear her story. And if she had done that without the High Court order being dealt with, she would have fallen foul herself out of the court order. So I'm explaining this because it leads then to the submission where we say that the current provision that proposes that I will read it. So it says that, at section 3B A, it says 3 capital letter B, the proposed amendment, it says the court before which criminal proceedings contemplated in subsection 3 have been concluded may, on application of an accused, a witness or person contemplated in subsection 3A who has attained the age of 18 years, grant an order authorizing the publication of information which reveals the identity of the applicant if the court is satisfied that the applicant understands the nature and effect of a court order in terms of the subsection. Now, the first problem with this proposal is that it assumes that it almost operates as if there's going to always be a court order for protection, and we that's not the case. We know that the protection is automatic, right? If you're under 18, you have that automatic protection, and that's what these amendments are strengthening. And then, so there's no court order. So therefore, it's odd and actually problematic that then once you turn 18 and you want people to know who you are, you then require to approach a court. There was no court order for your protection. You were protected automatically. Now you are going to have to approach the court and say, I want to reveal my identity. As I say, because there's no court order before, where there's a court order, one can understand, as in the case of KL. But where there was no court order before, we submit that there's no reason why that person must now approach a court to get that. Also because it's also, it's something that requires money. You have to then get a lawyer to help you apply for a court order to say that you can publish your own details. Whereas, you yourself should have the right to say, I want to tell my story, like KL wanted to tell her story, and therefore I'm going to tell people that I'm that girl who at 15 was abducted, and this is how it went, the situation unfolded. So, I mean, in terms of also, access to justice and not making the lives of people who were victims, witnesses and accused difficult, we would not support this automatic, this provision that they must then apply to the court. It's quite odd. And also I wanted to just highlight to the members of Parliament that in the judgment, there was a dissent by Justice Cameron and Justice Froneman. And when one reads that dissent, it cautions against this approach. One supports the majority because majority was on point in relation to the extended protection beyond 18. But the minority does make an important point, I think around paragraph 137, where Justice Cameron kind of says that, why do we expect these people who have been victims and who may want to tell their story to then come to a court and apply where there was no court order? It's a problem in relation to really access to justice, but also from his point of view, is a problem in relation to kind of stigmatizing the people. So we support the protection and we put it on record, the protection for under 18s and the continued protection where people elect to continue to have that protection should not automatically fall away, which is what the current amendments then achieve. But where the person wants to then publish their own story and tell their own story, that person should not be required to then have to apply to a court in relation to that, because that's a cumbersome process and it serves no purpose, particularly where there's automatic protection and you didn't have a court order. And I think this aspect may have been put in because of how things unfolded in the KL case. But I want to remind the Parliament that in KL it was different because there was a standing court order that said nobody could publish her details, hence the need for her to go back to court before she published her book. And Chair, with that, we're grateful for this opportunity, and we're grateful that the amendments have also been taken up as speedily as they are, because it's a very important issue particularly for people who are for children. And we support this process. And just wanted to highlight these two our suggestions, and we hope that they will be positively received. Thank you, Chair.
Thank you very much, Center for Child Law, for your input. Members, are there any comments, questions? I think members are satisfied with your presentation, Mr. Oza. The department would respond in due course when we do clause by clause. Or do you have any preliminary responses, department, but will still allow you time to digest what has been raised?
Good morning, Chairperson.
How are you, Ms. Pillay?
I'm well, thank you, Chairperson. Thank you very much.
Thank you.
Chairperson, we've noted the submission, and I think we will consider it when it's time for us to make our inputs. But we thank the Center for Child Law for those inputs, and we will definitely consider them and take the opportunity to call on them should we require further clarification when preparing our responses to the committee. Thank you, Chairperson.
Thank you very much, Ms. Pillay, and thank you to the previous presenter. Can we move to the next item, which would be minutes? Members of the public can still stay if they so wish, but we are done with the substantive parts for today. We will just be dealing with the minutes and the program. So if you want to stay with us, you can, but if you want to leave, you are free to do so. Even members of the department, if you wish to do other things, you are released to proceed and do them. But if you want to stay with us, we are also welcome to do so.
Thank you, Chairperson. I think the members of the department and myself would like to be excused, please. And we will be on the platform again tomorrow morning. Thank you very much.
Thank you very much. Have a good day. Can we fly to the minutes? Draft minutes of the Portfolio Committee on Justice and Correctional Services dated 17th August 2021. Are there any corrections on page 1? Page 2? Page 3? Page 4? Can you go to page 3? I think is that Mr. J. Jeffries? Is that the correct surname? It's page 4 at the top.
Jeffrey.
Yes, I think should be corrected. That should be corrected. Page 4, page 5. Is there any move for the adoption of the minutes as corrected?
Chairperson, I move for the adoption of the minutes as corrected.
Honorable Maseko Jalian moves for the adoption of the minutes as corrected. Any seconder?
Swart to second.
By Neodra.
Oh, Honorable Swart seconds. Any objections? The minutes are agreed to. Second set of minutes. Draft minutes of the Portfolio Committee on Justice and Correctional Services dated 18th August 2021. Are there any corrections on page 1? Page 2? Page 3? Is there any mover for the adoption of the minutes?
Chair, Honorable Maseko Jele, I move for the adoption of the minutes.
Honorable Maseko Jele moves. Any seconder?
Wilma Neo-Druchen seconds.
Honorable Nivo Drachen seconds. Any objection? None. The minutes are adopted. And do we have any sets of minutes that have not been adopted? Committee Secretary?
No, Chair, we don't have a seat. We're
Okay.
up to date, I think. No.
Okay. Can you flight the agenda so that can you flight the program so that members can see the changes that have been made?
Can I quickly try and take memos through? Sir?
Yes, please do.
We, as Mr. Honorable Swart has indicated that we would want 2 days. We then brought we're looking on the 24th of August now. We then brought the public hearings, of which we just concluded them today. And then tomorrow we will have the Department of Agriculture and the Department of Trade and Industry. On the 26th, which is Thursday, we had applied to sit during plenary. During the meeting, we managed to secure that approval. That meeting is approved, so the notice will be amended accordingly to indicate the 2 meetings of the 26th and the 27th. The subcommittee for Friday, we received approval. On the 26th, Chair, as you can see, written in orange there, I propose that we get the responses to the submission made today, because it's only one submission and the department had that submission a while back. We did forward it to them, but subject to their availability, we will come back to the committee. But that's the proposal I'll be putting forward, that Thursday they come back to us and make responses so that we can quickly finalize this bill. Week 3, on the 31st, as proposed by Honorable Swart, that we need to have 2 days. We managed to secure those 2 days. However, we still need to apply for permission to sit. We had envisaged that we would have received the GBV bills with amendments from the NSOP Select Committee, but the Select Committee has tabled the reports on the bills, but the bills are not yet referred to us. And given the public interest on this bill that we dealt with, the Cannabis bill, we propose that that day be a full day, those 2 days be full days on the hearings. We therefore will have to move, if the bills will be referred before the end of this committee, the GBV bills, we'll have to move them downwards, Chair, towards the end of the program, not to be part of those full days. Hence, you will see that the proposal says to continue with the hearings. On Thursday, we'll also have to apply to sit during plenary that following week to deal with if the GBV bills will be referred to us at that particular, on the 2nd, we will have to get those briefings on the amendments, and then afterwards we adopt the report. You will remember we received the briefing on the legal practice council regulations. We want to finalize that, and we also have a magistrate commission report that we plan to be briefed this Thursday. So we hope we would have finalized that and consider that report. And also by then, we hope that we would have received the responses that I proposed, that we proposed previously on the Criminal Procedure Amendment Bill. Then we propose that we deliberate on that so that we can quickly finalize that bill as well. On Friday, the 3rd of September, TCS, the subcommittee will be meeting. There's a plenary that starts at 10 till 12:30. So we plan to meet at 1 o'clock. The fourth week, we plan, because the applications are subject to close on the 31st of August. So we had planned to have received the applications and have made summaries on the presentations, on the CVs and members sent to members. Remember, we have vacancies that we still need to fill or on the information regulator. So we plan to deliberate on those, and we will apply to meet during plenary. As I note, the program is quite hectic, Chair, and the time is of the essence. We're going to plan and to apply for permission to sit throughout the days, as I note now going down. We would plan that on the 8th, we will get responses from the department if we would finalize the hearings on the cannabis bill. On the 10th, then the subcommittee will meet. Week 5. For now, Chair, as I was amending the program, I note that the deliberations on the criminal procedure amendment bill, I now have brought them forward. So this will fall out, and envisaging that we would have received the bills from the NCOP committee. The deliberations on the GBV bills will be subject as getting those referrals thus far, but that was the plan at that particular moment. And we will deliberate on the following week, as on the 15th, deliberate on the cannabis bill. But on the 15th of September, we would have finalized the criminal procedure amendment bill. We are going to amend that. The program speaks to that, because this current plan, it was before we brought the hearings forward. On the 16th, we'll be deliberating on the cannabis bill and also the GBV bill subject to referral. 17th, the subcommittee will meet. On the 21st, we plan to have the interviews of the information regulator for the 2 days. We had planned, there are 4 positions that we need to fill. So we planned that we don't know how many candidates will the committee shortlist. Hence, we set aside the 2 days. The committee will decide after receiving the interviews and deliberate on the event. On the 23rd, we'll deliberate on the cannabis bill. On the 24th, we will deliberate and consider and finalize the cannabis bill, hopefully, because that following week will be the last, the 28th will be the last week. The 28th will be the last day where the NA will be considering legislation. So we need to, if we want to finalize the cannabis bill and any other bill, we would need to finalize on the 24th. So the program will eventually change as we go, Chair, because as I note that there's a lot of interest on the cannabis bill. Maybe we might not even finish the hearings on these 2 days that we had planned, but so far we are liaising with the stakeholders who are involved and who have interest to come and make presentation. We will table that proposal before the end of this week, the list of stakeholders and how we're going to schedule them in terms of time. I thank you, Chair. Am I still audible? I think I'm done, Chair.
Sorry. I see you have scheduled a meeting for on the 24th of September, which is a holiday.
that will be amended, Chair. My apologies.
Members, one, it's something that we might need to think about it, is the letter that was circulated to you today with regard to Ms. Van Schalkwyk, a chief magistrate in Kempton Park. In fact, she is planning to review the decision of the Magistrate Commission. The issue would be for us whether we would want to have that briefing on Thursday, or we can have a discussion whether we will await the review application, in which case we might, if the review application is heard at the High Court, we might still need to come back and get the briefing, whether we want to have two briefings or we just have a briefing when everything has been concluded at the High Court, the review application, or we will still receive the briefing on Thursday and we take it from there. I think that is the first thing. It's something that we have not had time to digest it. It was circulated to the letter circulated today. Honorable Nigot Drachans, followed by Honorable Swart and Honorable Jelle.
Thank you, Chair. I'm just going to the program. I'm looking at Thursday, the 26th of August. I see the time on the left says 9:30. And I wanted to know, we have a caucus schedule on the parliamentary program for 10 o'clock. So I wanted to know whether we continue with the 9:30 meeting, or is it only during plenary time, 2 o'clock, the 26th of August?
It will be during plenary time. We cannot tamper with party caucuses from 10 to 1. So the meeting will have to be after the party caucuses. Who is the next speaker?
I think it's Swart.
Honorable Swart.
Chair, thank you. I'm not sure about the letter from the Chief Magistrate. I haven't had sight of it yet, but I will follow your lead in there. I don't have a view either way. You seem to be suggesting that we should continue with the briefing. I don't have any major opposition to that, depending on what the other members say on that score. So for discussion of the committee, as I say, we haven't read that letter yet. Chair, then secondly, I appreciate the fact that we have a lot of work to do, and obviously we will be sitting during plenaries, and I need to then note my apology up front as whip that I would need to attend plenaries. I will obviously try to move backwards and forwards as much as possible, but that's just one of the things I appreciate. We have to complete the work. Chair, I did indicate to you I had some concerns about the legal practice regulations. We'll need to consider that. We did receive the comments from the Bar Council, and I think the committee needs to just look into that as well before we accept those regulations. Then lastly, Chair, on the cannabis bill, I do appreciate that we've now got 2 full days for hearings, and one would like to have a list of the submissions received, and I presume all the submissions will be sent to us, and then of course who has been invited to make oral submissions. We would need an indication of that as soon as possible. I must say I'm doubtful that that process will be finalized in 1 month, given the complexities, we're just starting to grapple with the large number of issues around that. But I appreciate the programming that has been set out by our secretary, by Mr. Sia. So let's see, but I must sound doubtful that that process will be finished in 1 month. Thank you, Chair.
Thank you very much, Honorable Jada.
Thank you, Chairperson. Chair, one welcomes the changes on the program that we have made and note them. We agree, but also, Chair, I wanted to take you to the program on the 27th, which is Friday. That program, it is taking place when we have Women's Caucus, Women's Parliament program for this year. I think, Chair, we would want to send the apology up front in line with what is really happening these days and what has been happening in terms of the issues pertaining GBV women. One would want to really honor that one. I don't know if maybe it will be a transmission from our department if we are not available in honor to women on Friday, that we are not part of the committee. We put our apology up front. Thank you, Chair.
Thank you very much. It will start from what time to what time?
I think Honorable Balma will assist me, but it seems as if we're starting from the morning. It's just that I don't have the exact times here with me. Let me just check here. But it's like we're starting in the morning, Chair. I should think so, because it's kind of a whole day thingy.
Okay. No, it will be this coming Friday.
Yes, Chair. This on the 27th. Yes.
27th. Can we interact with Honorable Janji and come back to
Progress.
To a time even after that? I don't have a problem. I'll be available. Thank you, Chair.
Yes, and then Honorable Self.
Chair Wilma here.
Honorable Nibotrachen.
Yes, thank you, Chair. As Honorable Jele asked me the time, the start of the Women's Parliament is 10 o'clock, and the top item is gender-based violence reports, updated report back on the progress. So I do think it is very important for us to see to that, and it starts at 10. So just to mention that.
Okay. Yes, no, let's, I think the proposal from yourselves, if I get you, is that we can look at postponing one, or if not, an evening session, because at the same time, if you start at 10, around 5, if I'm correct, it might not be ideal to have another meeting after that. But we have to look at how do we recover these 2 days that the subcommittee would not be meeting. We would look at that. We will come back with a proposal. I think we will work with the chair of the subcommittee and the secretariat to see how do we recover, or how do we make up for those days. I think let's rank the priorities for this term. I think priority number 1, it would be to comply with the Constitutional Court's judgment that we have to complete. That is a criminal procedure, because the deadline is in December, and it still has to go to the NCOP. That is our number 1 priority for this term. That has to be done. The second priority for this term, which we have to do, is to ensure that the legislation, the GBV bills coming from the NCOP are dealt with expeditiously. That is the pressure we really have, is to ensure that I'm told that the amendments from the NCOP are mostly technical, consequential amendments, the use of binary language. So let's deal with that. Let's ensure that in these 2 terms, that is done. The third priority for the term is the information regulator. Their term is coming to an end in November. That we have to do. Then all others, it will be guided as to how far do we go, because we have to prioritize these 3. One, to ensure that we respect the Constitutional Court. We meet the deadlines. We made that promise when we started our 6th administration, or our 6th term as Parliament, that we do not want a situation where Concord judgment are not complied with. So if we do these 3, then the 4th one, it will be to ensure that time permitting, we conclude the cannabis bill, and then the issue of the regulations, the legal regulations. But the top 3 that we must conclude is the criminal procedure, the GBV bills, and the information regulator. We must also bear in mind that every time we do the interviews, we always have challenges with the screening process by SSA. That is one issue that we must also factor in the program, and we monitor them very closely so that we are able to meet the deadline. Then we will have to ensure that we make up of the 2 days that we would have lost for the subcommittee within the program. We agreed that the subcommittee's work should not be treated as a stepchild. We would want to create space for them to make up for the lost time. But for us to say that we have successfully implemented the program, we have to ensure that those 3 are concluded. By the time we adjourn, the GBV bills should be on their route to the President for assent, and the criminal procedure en route to the NCOP, and then the information regulator also, they should be on their route to the President for appointment. So any comments, members? Are we fine?
Yes, Chair, we are fine. Thank you.
Fine. I think we have come to the end of the meeting. I think the final parting shot is that it's quite clear that our program would be a living document, but let's ensure that every week we present an updated program that would have taken into consideration the processes. For instance, when we have received the GBV bills from the NCOP, so all the amendments and the updates, you will be updated as the committee, so that it's a packed program, and even the next one, it will be packed. We are planning to invite public comments as per the decision of the committee on the hate crime, hate speech bill. I think they should be advertised by this weekend, and we'll give them a month. And then after that, when we come back the last quarter, we will see how do we process that, whether it will be this year or early next year. And because when we come back, we will deal with the annual plans of the departments. And then when we are done, we will look at the hate crime, hate speech bill. So even the next term will be as tight and packed as this one. Thank you very much, members. The meeting is adjourned.
Thank you, Chairperson.
Thank you.